IA for leave to appeal, my lord. My lord, I have already filed leave to appeal, my lord. My lord,
What is the defect?
my lord, defect they have cited, my lord. Petitioner was not a party in the impugn order, my lord.
So you have filed a leave to appeal.
My lord.
Yes. Give the number. Yes. Then the defect is removed. Yes. It is submitted that this restoration. No modification recording on order. No restoration. None of this for the appellant. The interlocutor application stands dismissed for prosecution. Where is? Page 9. The order is not next to the file. That's why I'm asking. Order is there. Page 9. Now they have filed for recalling of this order. None appears.
None.
Dismissed for default.
Item number 3.
My lord, order record. Sorry, my lord, my lord. My item is serial number 2, my lord.
Is it not to?
How do I know? Nobody responded. How do I know that you are appearing, sir?
Sorry, my lord.
Why you did not respond? What the item number 2? Have you been served the copy?
Yes, madam. They have served.
Why you did not appear on that day?
Sorry, my lord, that inadvertently.
This is an application for restoration of the IA as well. The copy of the condonation.
Condonation application, I'll have to verify, my lord.
If it is not, give him a copy.
Oh.
3.
Item number 3.
Pray for adjournment to next week. Not ready in this.
1 week after.
Item number 4.
On defense of your lordship's order under annex to 1, I am before your lordship. Lordship may kindly
The
note.
contempt. Our orders are not complied with. Never complied with. Yes, Mr. Das.
Yeah, your lordship may grant me time till next week. I'll see that.
Have you been served the copy? Because
Yes.
the notice has to go in the contempt. This is a contempt.
But they have served our copy,
Normally-
but notice has to go in the contempt.
Notice to 2 weeks after.
Bless.
Item number 5.
Cancellation.
Cancellation of RC cancellation.
I am for the department.
Where are they? Who is appearing? Sangram Kesari,
Burma.
where is he? What is this? The rain is advanced. Call him. Do you know him?
No, Lordship. No, Lordship.
No. Do you know Mr. L.
Burma,
Pradhan?
Burma is Mr.
Yes, Lordship.
Sahus. Your chambermaid.
Call him. Next.
Item number 6.
Well, that's, sir, in the absence of appellate rep.
Disposed of.
Item number 7.
Registration cancellation.
Yes.
Item number 8.
This is regarding GST registration. GST registration cancellation.
Next.
Item number 9.
And look, this is identical to it. Cancellation of registration.
Item
10.
number 10.
This is regarding the 734.
Yes.
73 for B.
When the Supreme Court has seen those matters,
17.
Yes.
17 December. Yes.
Item number 11.
Same, my lord. Cancellation relates to cancellation of registration certificate.
Item number 12.
Contempt.
Yes,
Have
ma'am.
served the notice.
Yes, ma'am. State was directed to file the compliance affidavit. They have already filed. I have also received.
They have filed.
Yes.
They have complied
Yes, ma'am.
belatedly
Yes, ma'am.
or within time. What?
With their contention, they are earlier disposal.
Yes.
Already complied. Ma'am.
Belatedly or within time. I am
Within
just asking.
within time. Ma'am.
Within time. So then why the contempt does not lie?
Yes.
Where is the compliance?
They have filed the complaint. Wait, madam.
Yes. What do you say? You are not there. Oh. Where is the direction passed by us? Where is the operative portion of the order?
A pretty personalized manner. Page 8, man. As agreed by the learning council for the party, after going through the record, this court without expressing an opinion.
Consider the representation.
Yes, ma'am.
Mr. Raj.
We have filed a compliance affidavit. It has not come on recording. We are filing, my lord, before 2
This is here. We are taking it on record, sir. I don't go by the technicalities.
My lord. Obliged.
Why? The instant contempt application. Go on.
Further progress.
Item 14, my lord, service against OP number 4 may kindly be held sufficient because
Yes, sir.
this is orders matter. The service against OP number 4 is to be held sufficient in view of the postal tracking report.
My lords,
Noting is
I have instructions. My lords, I'm appearing on VC. I may be permitted.
Sir, what is this matter? What?
regarding a PIL matter
What? Relating to what?
relating to the encroachment of communal public land by a industrial unit,
What is this public land?
a gochar land.
Which is for grazing of the cows or for?
Yes, ma'am.
So
A
we have
report-
passed an order in one of the public interest litigation.
Yes.
The government has come up with the no tolerance policy so far as the encroachment is concerned. And
A report is also there submitted by the ADM.
oh, this is
My
a
lords.
restriction application.
My
Yes,
lords, it's an application for restoration. Their PIL was dismissed for non-prosecution, my lords. I have instructions to appear for opposite party number 4.
4.
My lords, I request I may be served with a copy so we can file an objection to the
Copy.
restoration.
Please appear for opposite party number 4.
For the opposite party.
Notice
He has a
sent.
right. He has a right to be heard.
Yes,
Not
yes.
copy on Mr.
ma'am.
Ashish Mishra.
Yes.
Record. He appears and submits that he has instruction to appear on behalf of the opposite party number 4. Stop. He prays for a direction to serve a copy of a restoration application. Stop. The petitioner is directed to serve the copy of the restoration application upon record his name. Today or Monday,
Because he will not available here in the.
I do not know where he is available.
He is not available. He is regular practitioner here, sir.
Because he is in VC.
I have been seeing him since last 5 years, I think.
Anyway, within Monday.
By Monday. Yes.
Item number 15.
Malad, there is a delay of 347 days.
Serve the copy.
I'll take notice. Question.
Notice 2 weeks after.
Item 16.
Wait till me. In fact, the hearing was closed with regard to debarment matter, my lord.
I think it was closed when?
Not the last Friday, my lord. Last Wednesday, my lord. Can you recollect the debar?
Keep it on Monday. Then we'll dictate in the open court.
Right.
We'll dictate in the open court. Keep it on Monday.
Item number 17.
The condonation application.
Right.
Have you served? Issue notice on condonation. 2 weeks after.
Item number 18.
What is this CMAPL? What is this? Restoration. Say service director. 2 weeks after the week.
Item number 19.
My lord, in this
What is
item
the
number 19,
content?
during the pendency of the petition, the petitioner died. I have filed for substitution.
What is the
legal-
matter?
This is a
WP.
matter of land
Whether right to sue survives.
land acquisition matter.
Land.
I have filed for substitution of legal heirs.
How is there any delay within 90 days or beyond 90 days?
My lord, beyond 90 days.
Then-
I'll file a condonation of delay.
Condonation.
Sorry, sir. Delay petition.
Once the 90 days expires, it abates. Have you filed an application for setting aside abatement within 60 days therefrom?
I'll file. May
Sorry?
be permitted. May be permitted.
And if 60 days also expired, then
60 days is there within 60.
The IA copy is not served.
I'll
The
solve.
brief is not ready.
The affidavit has been filed in.
Is on the prayer of the petitioner adjourned. Take step.
20.
To item number 5, I
Uh,
have instructions that it is a registration cancellation matter.
On his behalf, you are.
Yes, sir. I've made the necessary corrections.
Stop. Verma.
Is 20.
Obliged.
Tibrewal.
20
Item number 20, sir.
is the 20 is the content.
Item number 20.
First time.
No, no, sir.
No.
Second term.
Second time. Track report. None appears matter to appear 2 weeks after.
Item number 21.
Sorry to keep you waiting because these are the matters.
No, I'm grateful, my lords, for. First of all, I must apologize on the last occasion. I had to seek an accommodation, my lords, because of being unwell.
Yes.
And I'm grateful for that, my lords.
No.
If the lordship will recollect, Lord, I had made 2 submissions. One was, Lord, about whether section 4 capital B of the Mines and Minerals Development Act 1957
Yes.
continues to exist after
The repeal.
16 of 21. The lordship declared there were 2 amendment acts, Amendment Act 2 of 20 and 16 of 21. This 4B had been inserted by Act 2 of 2020. Act 2 of 2020, you shall also find in the footnote of it. The significance of this submission was, my lord, that the rules, sub-rule 1A, 1B, 1C, basis which they seek to recover additional amount on failure of dispatch, that is tailored to this section 4B, and not only section 4B, but if I may place section 4B, my lords, conditions for efficiency in production. Notwithstanding anything contained in section 4A, the central government may, in the interest of maintaining sustained production of minerals in the country, prescribe such conditions as may be necessary for commencement and continuation of production by the holders of mining leases who have acquired rights, approvals, clearances, and the like under section 8, capital B. Then section 13, under which rule-making power is there. The law shall see that section 13(1) is not the ordinary rule-making power which is for carrying out the purposes of the act, but it is very limited. The central government may, by notification in the Gazette, make rules for regulating the grant of mineral concession in respect of minerals and for purposes connected therewith. So this is tailored to the grant. Rules regulating grant. And there are auction rules made for under with respect to 13(1). Now 13(2), by the same Act 2 of 2020, they added AA, the conditions as may be necessary for commencement and continuation of production by the holders of mining leases under section 4 capital B. And then AB, the conditions to be fulfilled by the new lessee for obtaining necessary rights, approvals, clearances, licenses, and the like under the proviso to subsection 2 of section 8B. So these two, along with section 4 capital B, were added to enable the making of rule, pursuant to which, if Lordship will have the 2016 rules, the minerals other than atomic, at page 572 of your Lordship's Bare Act notes.
Yes.
Now, initially, my lords, they added rule 12 capital A, 1 and 12A capital 2. Notwithstanding anything contained in any of these rules during the first 2 years from the date of execution of new lease, the holder of mining lease to whom the order of vesting rights, approvals, clearances, licenses, and the like have been issued under section 8B shall maintain such level of production so as to ensure minimum dispatch of 80% of the average of the annual production of 2 immediately preceding years on pro rata basis, failing which appropriate action in regard to the in accordance with mine development and production agreement shall be initiated. Kindly for the time being leave 1A, 1B, 1C. I'll come back to it. Then the other was sub-rule 2. The new lessee shall ensure that the annual production beyond 2 years from the date of execution of new lease is equal to or more than the annual production by the previous lessee and shall subsequently work out and implement an annual production plan to ensure that the mineral resources are fully exploited during the period of the lease, failing which appropriate actions in accordance with the mine's development and production agreement shall be initiated. So both 1 and 2 sought to introduce a condition that you will ensure that the previous 2 years production will be maintained and 80% of that will be dispatched, failing which appropriate action in accordance with the mine's development and production agreement. That was the scheme. Now then, my lords, if you all shall see another significant and somewhat unusual provision, there is a compilation note which Mr. Singhvi had given where all the amendment acts were there.
You the one?
Yes. No, not. This is the Gopal Subramanian by Dr. Singh. Spiral one.
Spiral.
Yes, spiral.
I think it is volume 3, I suppose.
Volume 3.
Lords have got this. At page 81, section 1.
Yes. Yes.
This act may be called the Minerals Law Amendment Act 2020. It shall be deemed to have come into force on 10th of January 2020, without prejudice to the effect of the amendments made by this act, it shall remain in force for a period of 60 days from the date of assent by the President, and shall be deemed to have been repealed after the expiry of the said period. Once it has expired, ordinary law which is dead.
No, if the purpose is already carried out, then what remains? Then it becomes practically, I would say, the dead letter.
Yes, that's what I'm submitting. That was my submission, my lord, that section 4B, once it was inserted by this act, which clearly expressed the intent that this amendment act as a whole will live only for 60 days and will expire. That under 4, and the initial expression is important, without prejudice to the effect of the amendment. So the effect of the amendment was saved, namely whatever rules you have already made.
Once it is already incorporated and
So
amended.
12.1 and 12.2, which I read out, that is the effect which is saved expressly.
True.
Now, thereafter, 4B would not be available for further rule making in 2021.
Why?
Because 4B, my lord, stands erased for two reasons. Once, my lord, it is an expiry of this Amendment Act. And then it is coupled with a fiction, it will be deemed to have been repealed after the expiry.
So what would it be? This is an Amendment Act. Suppose by virtue of this Amendment Act, a provision has already been incorporated or amended in the parent statute. So the purpose is served the moment the amendment is carried out.
So
but that amendment will not be guided by this, because this act will come in, because the object and the purpose of this amendment act is already achieved.
But there is a contraindication of legislative intent, namely that it seeks not to save the amendment, but to save the effect of the amendment.
That is what the word is, without prejudice.
To the effect
Correct.
of the amendment, not effect of the Amendment Act. The Amendment Act goes as a whole.
No. Its effect means by virtue of an amendment act, amendment is carried out in the parent statute. Say the substantive statute. The moment the amendment is carried out, then this amendment act really loses its efficacy, and if they have decided to delete after 60 days, because
that would be the effect if Section 6 capital A of the General Clauses Act would be applied.
That is the repeal and the saving clause, and then the another one, the 6A.
That's right. So there is, if your lordship looks at Section 6A, 6A is not attracted, because here the repeal by fiction is happening after the expiry. The judgments of the Supreme Court, the judgments of the Supreme Court are very clear that if a temporary act is expiring, then Section 6A, they don't apply.
No, I'm conscious.
Yes.
Because in another state where I came from,
yes,
I think I have indicated to Dr. Singhvi also that concept, because there was another act which is called a West Bengal Requisition of Land Act of 1948 or 49.
Yes.
The legislature, while enacting this particular act, says that this act is valid for a period of 2 years. So there is a different concept. The acquisition and requisition are two different concepts.
That's right.
So requisition does not mean that a property has vested into the government or the right of the owner is taken away. It is for a temporary purposes the government is taking, and the rent is being ascertained and determined and paid to the owner.
Yes.
So that act was extended from time to time for 2 years, or another 1 year, for 2 years. And ultimately, at one point of time, the government decided not to extend. So the moment the period expires, then that particular act is no longer in the judicial or in a statutory field. But there was a corresponding amendment in Act 1 of 1894. That's the Parent Land Acquisition Act. The state amendment was introduction of section 9A and 9B, where a fresh lease of life was given that if the government really want that this requisition property is really required for the public purposes, another breathing time was given to give them a notice for acquisition and then proceed to decide the matter. Then the question arose that once the act lapsed by, I think, by flux of time, then in that event, what would be the effect thereof? If the acquisition proceeding is not taken,
Yes.
does the requisition continue? The absolutely uniform decision was that the moment the act lapses,
Everything goes.
then everything which has been done under that act will not be validated, and the government has to revert back all the requisition properties to the respective owner.
That's right.
Subject, however, that if you have gone for a requisition, then is another story. So this is what it act says, that once the Amendment Act lapses, so it is definitely not occupying this space in the legislative field. To that extent, I can understand.
Yes.
But if the purpose has already been done, can it be undone?
So my respectful Lord submission for consideration is this. That's this 1(3) seeks to read with Lord this provision which inserts section 4B, that is section 2. That, my lords, the intent is that it should enable the government to make rules for purposes of 2 years only. If you should recollect initially.
So what will happen? Subsequently, the central legislation, I'm just understanding, central legislation is being amended by the Amendment Act. Subsequently, once the amendment is carried out in the Parent Act, by virtue of that Amendment Act, the government, the central government decided to repeal those.
So
then what would be the effect?
No, then section 6A of the General Clauses Act applies because the Amendment Act kindly have 6A. That's what Mr. Subramaniam pointed out to your lordships on the last occasion. Unless section 6A is brought into play,
General Clauses Act.
also please bear in mind this note that as my colleagues had already submitted, that section 8B purported to make the previous clearances and approvals of the previous lessee to the new lessee for 2 years. It was only for 2 years. Later on, Lord, by Act 21, it was made to run through the whole period of the lease. Where any central act or regulation made after the commencement of this act repeals any enactment which the text of any central act or regulation was amended by the express omission, insertion or substitution of any matter, then unless a different intention appears, that's one, the repeal shall not affect the continuations of any such amendment made by the enactment so repealed and in operation at the time of such repeal.
So there's a saving, practically is a saving.
Now, what is happening in our case is
not a repeal, it's case of a lapse.
Lapse, and the repeal provision says it will be deemed to have been repealed after the expiry. So it's not in operation. 6 capital A says it will be in operation.
Yes.
So there is Act A, there is an Amendment Act B which inserts, then it is operating, and while it is operating, then a third act comes which repeals it. Then not the amendments which made already by it, inserted or whatever, altered, that will continue. That's the purport of 6A. But in this case, it's not in operation. It's a fictional repeal which is happening post expiry. That's what the parliament itself is saying. After the expiry. So it's not in operation. First it says ceases after 60 days. So it's gone as it is. Then that is treated as an expiry. And third, it says there is no third act, in fact, in my case. It's not a case where an amendment act is operating and some other act comes and repeals. Because it's unnecessary. What has to be done, inserted, as my lords are pleased to observe that if it is inserted, well, it will live on. But that is not the case here. Here, the amending act itself ceases to operate.
Now, you are just trying to make a line of distinction between the two contingencies. One is that an amendment act is subsequently repealed by another act of the parliament. Then in that situation, according to you, 6A will
That's right.
clearly come into play.
Because that act
And-
is operating when
And
repealed.
it would be a different concept when the amendment act itself has a self, the
Expiry
life,
limit.
expiry life or a self life.
Yes.
And after the expiration of the period, it is it cannot be said to be a repeal. But even if the word repeal is just a fiction, it is in fact it lapses.
That's right.
So section
And
6A, 6A.
And there is a purpose of this fiction. The purpose of fiction is that, or your lordship's dictums, as my lord just now pointed out, was that section 6 is different from 6A. It protects whatever has been done, rights, liabilities, and so on.
True.
So, since 6 does not apply to expiry, therefore this fiction has been deployed so that whatever has been done under these amendments, that is not destroyed. That is why this fiction was deployed. Otherwise, this fiction makes no sense. What is already dead by efflux of time, my lord, you are killing again by repeal, has no sense. So therefore, that was my humble submission for consideration of your lordship's honors, that this 4B was not available for the subsequent amendment. Now, please look at that subsequent amendment.
Of 2000?
This in that compilation of Mr. Singhvi,
This is 2020.
At 15 of 21.
20.
At page 89, it begins. For the first time in 2021, that is, my lords, after 1 year of my lease, based on auction, 3AA, clause AA, definition of dispatch has been added. There was no definition of dispatch earlier. Means removal of minerals and so on. Simultaneously, my lord, FA, small Roman 2, adds FA, production. Also note at section 5, for the words mining operations, wherever they occur, the words production and dispatch shall be substituted.
Yes.
That is in subsection 4. In section 4A of the Principal Act, in subsection 4, this is substituted.
Yes.
And then section 9, 8B is substituted where that period of 2 years is now extended for the whole life of the lease.
Yes.
So one doesn't need to get the approvals, etc. again.
Yes.
Now, this having come, another GSR is issued. Please have the rules again. The 2016 rules at page 572 of the Bear Act. Now see what has been added. and this is added by GSR dated 10th of June 21.
Yes.
In case of shortfall in dispatch from the minimum dispatch required under sub-rule 1, please mark this is a very crucial expression. Required under sub-rule 1. So this is tailored to 1. And 1 is only for the first 2 years of the lease, which shall be assessed on a quarterly basis. The lessee shall, in addition to the amounts payable under Rule 13 of the Mineral Auction Rules 2015, hereinafter referred to as auction rules, for the actual dispatch, also pay to the state government an amount equal to the difference between the following, namely, A, the amounts payable under Rule 13 of the auction rules for the quantity equal to the minimum dispatch required under Sub-Rule 1 in the said quarter on the basis of the weighted average of grade of minerals dispatched during the quarter, and the amounts paid under 13 of the auction rules for the quantity actually dispatched in the said quarter. So there is a mechanism, my lord, if I fail to dispatch, then I have to pay this amount based on the formula which has been mentioned here to the extent of the shortfall. And I have to pay all the amounts. Though I am not dispatching, I pay royalty also, I pay the amounts, my lord, for the funds and the trust which have been created by 9B, Section 9B and 9C. Then 1B is inserted, where the lessee does not maintain minimum dispatch requirement under sub-rule 1 for the whole year as a whole, the state government may terminate such lease after giving the lessee a reasonable opportunity of being heard. Then 1C, in cases where the mining lease is executed on or before the commencement of the Mineral Rules 2021, the provisions of Sub-Rule 1A, 1B shall apply after a period of 1 year from the date of such execution of mining lease or the date of commencement of the Mineral Rules 2021, whichever is later. So these 3 rules have now been added by virtue of the rule-making power tailored to Section 4B and 13(2)AA and AB. If I am right, my lords, that Section 4B doesn't exist, these rules could not have been made. That's why the first submission. Second, my lords, assuming against myself that 4B exists, supposing it exists, my lords, one, it has already been submitted, my lord, by Mr. Singhvi, my lord, that this 4B says conditions to maintain and continue the production. It has nothing to do with dispatch. Whereas these 3 sub-rules are seeking to impose a financial liability based on failure to dispatch. The third, my lords, is that these Rule 1A straightaway contradicts Section 9, 9B and 9C. It requires me to pay royalty and the fund amount and the trust amount on failure to dispatch. Whereas Section 9, if your lordship will see, requires me to pay royalty at page 13 only when I dispatch, not failure to dispatch. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or in any law in force at such commencement, pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, sublessee from the leased area after such commencement at the rate specified in the notification. No royalty is to be paid by me for the mineral which I have produced from my mining operation, which is still in my leased area. It is only when I remove it from the leased area that I need to pay the royalty. And 9B, which is the fund amount, District Mineral Foundation Fund.
Yes.
9B5. The holder of a mining lease or a composite license granted on or after the date of commencement of the Mining and Mineral Development Regulation Act, other than those covered under provisions of Section 10A2, shall, in addition to royalty, pay to the District Mineral Foundation. I'm
Yes.
sorry,
No, it's
of the district in which the mining operation are carried on, an amount which is equivalent to such percentage of the royalty paid. Kindly mark, royalty paid. So when I pay royalty, a portion of the royalty I will pay also to the foundation. Identically, 9C is National Mineral Exploration Trust. Subsection 4 says, again, an additional amount for the trust. So all three are linked together with royalty, which I have to pay under the Act, under the parliamentary intent, only when I remove it, not when I have produced it and it is still in my leased area. Whereas 1A, which comes in 21 post my lease and post my agreements with them, ex post facto, and it seeks to impose an additional liability that I must pay this amount for failure to dispatch. So, my lord, it is straight away conflicting, my lord, with this requirement which the Act. There is nothing in the Act and Section 4B which says that you impose conditions for efficiency. In my humble submission, my lord, it has to be understood harmoniously with Section 9, 9B and 9C. It cannot be understood as empowering this delegated authority, the central government, to make a rule which runs, my lord, straight away directly in contradiction with the requirement of 9B and 9C. That cannot be, my lord, the intent 4B scope. One can understand that you have deployed some particular higher technology for efficiency of production, or that you produce less amount because of environmental damage, etc. Such can be the conditions. But it can't be that if you fail to dispatch. I can also understand that you minerals are required for downstream industries, etc. So you want to encourage. But my lord, who knows what Mother Earth will throw up? Ultimately, we are mining. We will sell only that which comes up, my lord. We are not an industry which is producing something, my lord, manufacturing something out of a raw material. It's the raw material which we are extracting. And secondly, how much we can dispatch, my lord, supposing there is COVID time, supposing there is export ban. When China was exporting, my lord, there was a huge digging going on and exports were being happening. But now once that stops, the relations are bad. Foreign affairs, my lord, they will dictate what to do, what not to do. So, but we are compelled, and if we fail, we pay royalty. And as was already pointed out, that if in subsequent year, my lord, if we sell this, we again pay. So this is something, my lord, which is manifestly and monstrously, my lord, arbitrary. After all, my lord, we are all miners. You knew what you want to extract money from us. You had several in the auction bidding parameters. You set out what upfront payment will be made. We made a bid of 15%. So as and when we dispatch, we add 115% and pay to the government for that. Now that is something which we know. Now you are post facto asking us to pay this for non-dispatch. The other submission, my lord, which I wish to make is that please see 1A is linked with 1. I emphasize the expression in case of shortfall in dispatch from the minimum dispatch required under sub-rule 1. And please again have 1. Notwithstanding anything contained in the rules during the first 2 years. So my lease is in 20, 21, 22. These are the first 2 years. So 1A liability at the highest blood can be imposed for the first 2 years, which they have already done in my case. Now my writ petitions before your lordships are for the 3rd and 4th year. How does 1A apply, my lords? On a plain reading, it doesn't apply to the 3rd and 4th year. It says in case of shortfall in dispatch required under sub-rule 1. And what is required under sub-rule 1 is the dispatch in first 2 years.
Yes.
And this 12.1 and 12.2, 12A1 and 12A2 were incorporated in my mine development agreement, which I will just now show to your lordships. So we have honored that. We are not saying that you can't do it for the first 2 years. Although there could still be a dispute, but still I'm saying that the 1A has been, assuming that 1A is validly inserted, it applies only to the first 2 years. This is made further clear, and this is not retrospective. Kindly see 1C. In cases where the mining lease is executed on or before the commencement of the Mineral Rules 2021. So my lease is before 2021. The provisions of sub-rule 1A and 1B shall apply after a period of 1 year from the date of execution of mining lease. So it seeks to exempt the first year because 1A has been inserted in 2021, that is after 1 year had expired. So it seeks to say that in such cases, it will apply after the first year has elapsed. So it's a beneficial provision. It does not, there's nothing in 1C which says that you can go on till the 50th year, 3rd year, 4th year, 5th year, 6th year, till the 50th year and go on charging based on 1A. That will run contra to the intention, clear patent intention, which is there embedded in sub-rule 1A. 1A can't be expanded beyond 1. So therefore, 1C has no intention of expanding it to the 3rd and onward years. It only seeks to apply 1 from a subsequent date because of its late arrival. So it says 1 year after the lease.
No, is it not some kind of a inconsistency? Because if you go by 12E1,
yes,
it says that immediately upon an execution of a mining lease.
It is a contradiction. My lords are right.
Then in that event, whatever the previous lessee made a production preceding 2 years,
You have to maintain that.
You have to maintain on a pro rata basis. That you have to maintain. That means this obligation under sub-rule 1 of Rule 12A starts or reckoned from the day of an execution of the
lease.
But 1A also talks about that you'll have to make a production as well as a dispatch.
As per 1.
As 1. If 1C is to be understood, then the postponement of that immediate operation of sub-rule 1
it runs contradiction.
Is there because it says that there will be a moratorium period for 1 year.
Yes.
Means 1A will not apply.
But it seeks to apply 1A from that date. So this complete an absurdity which is writ large. That's why Mr. Singhvi said it is manifestly arbitrary.
The intention is to be gathered. Then if first year is to be excluded, then definitely it engulfs the 3rd year itself.
And in my case, 2 years have expired.
No. If 1 year is to be exempted, according to 1C, that it will apply either after 1 year from the date of execution or coming in force of this amendment, whichever is latter. So once it says that means that up to 1 year there is a moratorium period or whatever, the exempted period. And this 1 will apply or 1A will apply thereafter from the 2nd year. And if you say restricted to 2 years, then it should be 2nd and 3rd.
That would be the logical thing, my lords. But this particular 1C 1C says, seeks to apply 1A as it is. And 1A doesn't run beyond 1. Somebody has not thought over it, not that the language is.
So the harmonious reading of the aforesaid provision, that there can be a distinction which could be made real and a patent, that it only applies to cases where the lease has been executed prior to the date of the amendment.
Correct.
It does not apply to a leases which is executed after the.
That's right. That would be
after the amendment, if it comes, then immediately 1 and 1A and 1B will come.
will apply from that date.
1A. And
That's the appropriate harmonious construction.
exemption.
I appreciate it. I apologize, and I bow down. My lords. That's the appropriate way, my lord, to harmonize, because it also goes on to say that supposing, my lord, the lease is executed on the date of the rule. First year and second year, no difficulty at all.
Before means on that date.
On that day, so first year and second year, it will apply, no problem in 1A applying. But supposing, my lord,
not on, it is after.
After, yeah.
Say the amendment is carried out on 1/7/21.
Now, whichever is later means if it is on the date, if it is on the date, 1 year, 2 years from that.
Executed on 2/7, then 1 year from 2/7/2021 to 1/7/2022 can be said to be a exempted period.
Exempted period.
And why it says so, that the lease may be executed prior thereto.
Correct.
And after the commencement, 1 year moratorium is given. I do not know how it is to be harmonized, because the things already done. Then can it be undone by virtue of this?
And that's what is happening in my case. For first 2 years, you have already applied. Now, for the third, fourth, how do you apply, my lords? Take 1A, 1B, 1C all together in a best possible construction in their favor. Yet it can't go beyond the first 2 years. That's the whole scheme. And it was all tailored to 8B as it's inserted earlier. That 2-year problem.
Yes.
Now this is further, my lord. Yeah.
This 1C must be limited 1 year, not spillover.
No,
my lord is saying 1 year only.
Only.
Yeah.
No. The difficulty is what is happening. So Dwivedi is arguing on that this 12A subrule 1, it talks about a period that first 2 years the previous lessee's production must be insured. First 2 years on a pro rata basis. Then he says that 1A was introduced, by virtue of which the dispatch concept is also imbibed. And if that being the position, then one has to understand that how to harmonize it. But 1C, it says that if the execution of the lease is on or prior to this amendment of 2021, then 1A and 1B, this operation would remain suspended for initial 1 year from the date of the execution of the lease or from the date of coming in force of the Amendment Act. So there appears to be an inconsistency in this regard. It says it will not, 1A and 1B will not apply for first year. It will not apply for first year, but it will apply from the second year. But it does not really in tune with 1A, 1.
The fact that it makes it clear that the moment the second year is over, who has to take over?
True.
And the fact that 1C says 1 year, then maybe someone is ironing out of that, whichever is later and all that stuff. The intention is clear to protect you only thus far and not further.
So that is what I gather is that if 1A say or 1 says 2 years immediately on the execution,
yes,
then 1C really carves out an exception.
Exemption.
That first year you are saved. That means if the 2 years is to be counted, then these 2 years have to be counted either, if we say harmonizing the provision, is that from the second year and a third year, because 2 years cannot be
Now, may I,
diluted. If
now,
there is a
Milord,
difficulty, second difficulty which will arise, that is what I'm saying. Then how to work out? Harmonize one A, one B with one C.
Please make some let me reflect on it.
Milord, sir, there, now, Milord, may I say,
That is why the 2 years is fixed, because it does not dispense with sub-rule 1. It simply says 1A and 1B for the first year will not apply.
so it's an
If
exemption
you
for the first year.
look at 1C, it simply talks about 1A and 1B. It does not talk about 1.
I see some of the
That is there is some kind of the bloodness has come, some
Yes.
kind of a, but one has to harmonize the provision. That is the first canon of.
So, Milord, there are, in my humble submission, Milord, there are two ways of harmonizing. One, as a law, one is that since 1A is to be applied and 1A, Milord, is to be applied, therefore, leave out the first year, apply it to the second and third. That's one. The second one, and which is in my humble submission more appropriate, is that the rule making authority, since it is making a rule in 2021, that is 1 year after the expiry of the lease, it is seeking not to apply 1A to the first year. It applies only to the second year which is operating. This is a financial default provision. It's a burden which is being imposed on a lessee on the basis of a contract pre-existing. Therefore, if there is two ways of harmonizing, then the better way of harmonizing will be that, not in the absence of clarity, that it should be in favor of the lessee, who's being caught off guard by this 1A, 1BC system, which was not there as a parameter in the auction. If something suddenly is being foisted on me, then the authority would feel that it will be unjust to foist this liability for the first year period, so only for the second year. It can't go on to the third year because 1A is not being changed. The text of 1A is not being altered by 1C.
But once the reference to 1A and 1B is there in 1C.
So, and 1A is linked with 1, so it has to be first 2 years only.
That is why the one has to understand that the applicability is.
If the government wants to dispense with the first 2 years is the crucial expression in 1. That has not been touched, not been altered. There is nothing to indicate in 1C that the first 2 years, it's a very clumsy draft.
Yes.
Now, if the other option which I am suggesting, Milord, kindly test it from yet another angle. There will be a lessee like me who, if 1 year is to be taken, then this 1A has already been applied for the first two years on me. My lease was of 20 to 2021, 21, 22. And from 21 July, when this GSR comes, 1 year will mean 2022 July. Only 2 days remained. On 3rd of July, Milord, my 2 years expired and 1A has been applied. For both the first 2 years, what will happen then, Milord? It can't mean, Milord, that now it will be applied for the 3rd and 4th year and 5th year. So my case is strictly confined to 3rd and 4th year. 2 years it has been applied. Now please see sub-rule 2 now. It is further reinforced that it can't go beyond first 2 years. And not just a well settled rule that a financial liabilities which are to be imposed must be done so with clarity and ambiguity. Nothing should be resolved in favor of the state if it is not clear. The new lessee shall ensure that the annual production beyond 2 years. So there is a express, separate, distinct and different provision for the third, fourth years. Beyond 2 years from the date of execution of new lease is equal to or more than the annual production by the previous lessee, and shall subsequently work out and implement an annual production plan to ensure the mineral resources are fully exploited during the period of the lease, failing which appropriate action in accordance with mine development and production agreement shall be initiated. 21 proviso is introduced. New lessee shall also ensure 80% of such annual production is dispatched. Now 1A doesn't apply a lot to the beyond 2 years. Let's keep aside 1A, 1C. 1A is limited to the first 2 years. Expressly says required under sub-rule 1, first 2 years. Now beyond 2 years, there is no question of applying 1A. How do they apply 1A lot to B? Under 2, the only action which is contemplated is appropriate action under MDPA. Whatever I have agreed with you, whatever is written there, take that action, and that should be appropriate action.
When a mining leases are or the agreements are being executed, it must indicate the minimum productions which you have to make in every year.
Yes, my MDPA agreement only for first 2 years. I'll show you. Kindly have. I'm grateful not for asking
about.
Yes.
Does it reflect any kind of a minimum production per year?
Only for first 2 years. Only for first 2 years. In accordance with 12.1.
I am talking about the agreement or a lease.
Yes.
I'm not talking about this, the effect of the provisions. I'm just talking about.
Yes, I'm showing you. I'm placing before my Lord the Chief Justice the MDPA. MDPA and then lease. The procedure is
what it says that minimum production should be per year or
only for first 2 years,
and thereafter
nothing is specified, and it incorporates 12.1 and 12.2 only. Not 1A, 1B, was not there at that time.
First 2 years, what they say is incommensurate
in accordance with 12 and
with the previous lessee's
previous
production.
lessee, exactly 12.1.
2 years.
Yes.
Suppose if there is a shortfall in the production,
then
what it attracts consequences.
Then appropriate action under MDPA. That's what it says.
Consequences.
Namely, you may take steps for termination, etc. That's it. Let me show to you, Lordship. Kindly have page 124 of my petition, Mills.
Take a hypothetical example.
Yes, sir.
That a previous lessee,
yes, sir,
he was supposed to ensure the production, say 50 metric tons per year. He could not make a production of 15 metric tons. He made a production of 7 metric tons.
Yes.
Much short, there is a stark shortfall. Termination comes. Reauction. New lessee comes. If the spirit of those provisions have to be taken into consideration, then it says that what they produce preceding 2 years. Is it not a farcical or
because that's
ensuring the short production?
Actually, these provisions were never there in the past. For the first time, this auction methodology, when it was introduced under Section 8AA, then, my lords, all these procedures were altered.
It does not say that what was there. It maintained such level of production so as to ensure the minimum dispatch of it.
If your lordship will have, my lords, the writ petition, my lord, the MDP, my lords, it begins at.
No, I'm just trying to figure out that how to understand this provision.
So, my lords, problems.
If the termination is founded upon less production, as agreed upon in the agreement or the lease.
Well, that also has
Then
to
in
be
that event, continuance of that particular shortfall,
no. So
as it appears, is does not appear a legislative intent in that.
So the state may terminate, may not terminate. It depends upon the
terminate.
It depends upon the explanation given, my lord. Is it force majeure? Supposing it because of COVID.
No, that is a different aspect. Force majeure clause is something different. We are not
And
concerned.
the second thing is
Clear violation of
the second consequence is that they can appropriate a sum from the performance security. That's MDPA. A sum of about 50 crores, my lord, is given as a performance guarantee. But that's the dispensation. Please, we can't alter the dispensation, my lord, which the government devised. This is the dispensation. And the lessee has paid 3 upfront payments before getting the lease. And given a 50 crore, so it's not, my lord, that something is happening, my lord, somebody can just cheat the government and get away, my lord. 3 upfront payments, huge amounts, and 50 crores, then the lease. I pay the first upfront payment, then letter of intent comes. Second upfront payment, then MDPA. Then third upfront payment, then lease is executed. So, and then, my lord's performance security is given. So that amount is there, and if your lordship looks at page 143, the MDPA. Let's not hurry. Page 124, kindly come to page 133. That is the Mines Development and Production Agreement. And this is a statutory agreement because the law requires that such an agreement be executed before the lease is granted.
Yes.
Lease will not be given unless this agreement is entered into.
Yes. The mining plan you wanted to define. What is this?
This is Mine Development Agreement.
I know what these are the
At page 133, 133, clause 1.120 is minimum production requirement.
Correct.
Shall have the meaning given to such expression in Schedule D. And 1.1.22 defines mining plan.
I know. That's fine.
Now,
yes.
Now please see clause 3 at page 136. Grant of mining lease over lease area shall be conditional upon prior payment of the third installment of the upfront payment, which is 12 crores 33. The third installment of 12 crores.
Yes.
Which means the first 2 have already been paid. So 36 crores, almost 37 crores.
Yes.
And then at page 138, at page 137, you'll also find the performance security.
Yes.
Now at page 138, 4.3.1, item 2, failure of the successful bidder to comply with the minimum production requirement as required under clause 8, value of performance security for each failure to comply with the minimum requirement as specified in schedule D. And then 5, failure of the successful bidder to make the monthly payment and payments as clause 7.12.
That's interest to be computed.
Yes. Then kindly come to page 142, that's the payments. All financial liabilities are set out. The successful bidder shall make monthly payments on the basis of the final price of
which clause?
I'm sorry, clause 7,
7.
page 142.
Yes.
The successful bidder shall make monthly payments on the basis of final price offer. The monthly payment shall be computed on the basis of the value of mineral dispatched. In case the annual production is less than the minimal production requirement specified in clause 8, the successful bidder shall make payments on the basis of the final price offer in shortfall within 20 days from the end of the year for the purpose of compliance with the minimum production requirement. The expression year shall mean period of 12 months commencing from the effective date of the mining lease and each subsequent 12 months period thereafter. The upfront payment paid by the bidder shall be adjusted at the earliest in full against the amount payable in accordance with the percent of value of the mineral dispatch quoted as the final offer on commencement of production minerals. Now please turn over leaf 143. That's the minimum production requirement. Clause 8. Compliance with the minimum production requirement. Point 3. Any non-compliance with the minimum production requirement would result in appropriation of
the five instances.
Yes.
During the currency of the lease.
Yes.
That may invite a termination.
Yes.
Not the first default or a second default.
Yes. Then a non-compliance performance security stipulated in clause 4, and in case where non-compliance with production requirement exceeds for 5 instances, then government has a right to terminate. Then kindly let's come to there is also note clause 17 at page 153, which is event of force majeure. And then 19.12 at page 157. Entire agreement. The mining lease inclusive of this agreement, including all such deeds, agreements issued or
clause
19.12.
Yes.
At page 157.
Yes.
Mining lease inclusive of this agreement, tender documents together with all documents referred herein and thereafter constitutes and represents the entire agreement between the parties with regard to the rights and obligations each of the parties and cancels, supersedes all prior agreements, understandings, if any, whether oral or in writing between the parties on the subject matter hereof in respect of matters dealt with, any conflict between lease, etc., and tender document, the mining lease inclusive of this agreement would have overriding effect. So all liabilities are crystallized now. I knew everything with open eyes. I made a bid and I need to comply with it. State also knows what it needs to get. And now turn to Schedule D, 161. Minimum production requirement. So they set out for the first year, 2 years, refer to Rule 12A, and 12A has been incorporated. Only 12A1 and 12A2, which was in existence at that time, has been incorporated. 1A, etc., has come subsequently, as the Lordship saw. And then look at the foot of the page. Production achieved during 1819 and 1920. This is my first 2 years. It is mentioned here. There is nothing about the third year, fourth year, fifth year, sixth year, seventh year. Neither the Rule 12A required, nor the agreement requires, nor the lease requires. And the lease, your lordship will find, it begins at 168. Effectively from 170. At page 170 onwards is the lease. It's a very short document. Basically, my lord, the MDPA goes along with it. As the lordship saw, the lease and the MDPA agreement are the two instruments which override and govern. Kindly see 3.1 at page 172. The rights and obligations of the state government and lessee shall be as specified in the Act and the rules made thereunder, including without limitation the Minerals Rules 2015 and the MDPA agreement dated 1/7/2020. So, my lord, the dispensation, the bidding parameters, the auction terms, the MDPA, the lease, all taken together were in compliance with 12A1 and 12A2 and envisaged a production target for the first 2 years, with which I'm not concerned. In my case, it's over, dealt with as per Rule 12A. We are concerned with third, fourth, and 12A2. What precisely, my lord, I wish to submit is that Rule 12A2 does not attract 1A. That's the first submission. Second, my lords, 12A2 itself bodily, expressly, specifically provides for a consequence, namely appropriate action under MDPA. Therefore, no other consequence, my lord, can be imported, my lord, by indirect stretched technique. Third, my lord, the proviso which has been inserted in 21, which talks of ensuring at least 80%, it is directory and not mandatory because it has no consequence. Proviso does not, my lord, contain any consequence like 1A. So therefore, in the absence of consequence, the methodology, your lordship says, my lord, that there is no consequence. So it is something, my lord, which I must keep in mind, try to achieve directory. It's not that I'm failing to achieve some financial liability of the nature of 1A or otherwise would fall on me. So therefore, that, my lord, is the my humble submission. And in my case, my lord, another issue, my lord, as was pointed out by Mr. Singhvi with regard to 12A2, just to restate it. Interestingly, my lord, 12A does not say annual production of the previous 2 years of the previous lessee. And that's where the confusion arose, my lord, and both the state government had written to the central government that what do you mean by this annual production? How are we to determine this annual production under 12A2? 12A1 says previous 2 years. Kindly see again first. (12A1) fourth line shall maintain such level of production to ensure dispatch of the average annual production of 2 immediately preceding years. Now this expression is not there in 12A2. On the contrary, 12A2 says that I will make out a working plan for the whole duration of the 50 years. Well, the lease under section 8A contemplates a grant of lease for 50 years to me. So there is some legislative intent of granting a discretion to me to organize, my lords, my work for 50-year period. I will take note of, my lords, for what minerals are available, and 50-year period is my time period. I may consume in 8 years, 10 years, 50 years. I can't be forced to consume it in 5 years, my lord, and be done with it. So 12A2 does not, my lord, link annual production with the last 2 years of the previous lessee. Now, whether this will mean, my lord, my previous lease was for 50 years, will it mean the average of the 50 years, average of the last 2 years, average of the last 10 years or 5 years, or nothing is clear from this. So the IBM and the state government both, my lord, have written to the central government that please clarify, which has not been done. So one doesn't know. And please link this annual production with this, and shall subsequently work out and implement an annual production plan. Now it is giving me a discretion to work out a plan. For what? To ensure that the mineral resources are exploited during the period of the lease. So I have the burden of working out a plan to ensure that the lease is worked out for 50 years. So necessarily, therefore, Lord, it can't be the static, fixed, unchanging. The letter of IBM is annexure 37 at page 315 of my petition. And what they are doing is, for the third, fourth, they are adopting the same principle of 1A and applying to me on the third, fourth, and possibly they will apply for 5th, 6th, 7th, and 10th, and 50th.
315.
315. इसका letter है ये? This is IBM's letter to the central government. This has a reference to letter number so and so from the Ministry of Mines on the above subject. And the subject note comments on the representation of companies regarding requests for relaxation of minimum production and dispatch requirements under MDPA signed as so and so, so and so. Then they quote 4B at the bottom. There is a reference to Rule 12A. Kindly come to an analysis, third paragraph at page 317. An analysis of production dispatch in accordance with sub-rule 2 of 12 of Mineral Concession Rules 2016, considering production committed in MDPA, presents very interesting and contrary scenarios. My lords, got this, please? My lord, the Chief Justice, am I on the same page, please? Presents very interesting contrary scenarios. It can be seen that in case of 02 leases out of 17, the production needs to be ramped up to unsustainable level.
Previous lessee, or whatever, they ramped up the production since last 2 years. And then in that event, it was highlighted that if 12A is to be strictly construed, then what will happen that if this parity or they have to maintain that particular level of production,
yes,
preceding 2 years, there are leases where the entire natural resources, the minerals will be exhausted either in 3 years or 4 years or 5 years or 10 years. It will not last 50 years. So in that event, they want a clarification that what should be the...
What do you mean by annual production? Especially asking the lessee to have a working plan for the whole 50 years. So it's a self-contradiction in 12A2. And secondly, I didn't get more than domestic. Therefore, the paragraph beginning, therefore, 317 last paragraph, based on analysis made in the foregoing paragraphs, it can be concluded that 12(a)(2) of 2016 were introduced as a condition to ensure raw material supply post expiry of leases in 2020, and production figures over the last 5 years it clearly indicates that supply of iron ore is more than the domestic requirement. So market is saturated, the production is already more, and I am to simply go on producing and dispatch to whom? I must have a supplier, my lords. Very important aspect, my lord, that supply presupposes that I have a buyer. Dispatch has to be to the buyer, my lords. So either the government, my lord, makes sure, my lord, is like the agriculture commodities, you are buying this from me, then I can go on produce and giving it to you. Then B says the annual production of previous lessee, whether over the entire period of the lease or specific, has not been defined in 12(a)(2). So therefore, is that 12(a)(2), my lords, is riddled with contradictory intentions flowing from one expression, the other expression, vague expressions, and the authorities themselves are not clear. So I submit, my lord, that it was rightly submitted that this is manifestly arbitrary, my lords, and in any case it doesn't apply beyond the first 2 years. There is nothing in 12(a)(2) to attract 1(a). And if I may show to your lordship just last one document, Lord, that is my demand notice, which shows that just picking up mechanically 1(a). The last 2 year figure at page 276, annexure 31. Where is that?
Yes.
Is the table.
First, kindly see, Lord, that page 277. What are they charging? As I submitted, Lord, they're charging not only the differential in the dispatch, but even the royalty, etc. First is the auction differential amount payable towards applicable amount quoted under 12. 2 is differential royalty. 3 is differential DMF. 4 is differential NMET. And the value of performance security to be appropriated. Everything, Lord, has been added for non-dispatch. Now kindly turn to page 279. Just mark item 1, minimum quantity to be dispatched in the third year. Same as in the first 2 years, 5,82,800 metric ton. This was in the first year. Second year, the same amount is being fixed here. Fourth year, fifth year, mechanically going on. And possibly there will be a demand notice for fifth year and then sixth and 50th, till the 50th. I'm not entering into the facts which the lordships are examining this, Lord. Otherwise, in my case, there are other problems on facts also, Lords.
Yes.
So, which I will address, Lord, later on in, if required to go into that. I'm good.
Yes.
Your Lordship, please.
And as you will address.
No, I am at your Lordship's service. I thought you can give me an indulgence sometime next week. I come physically and then make note of all these submissions. I understand some so-called irreconcilable contradictions have been pointed out, but I think we can find a a way of harmonizing them. So any date can be lordships after the 16th or 17th, and I'll come and assist the court.
You were coming on 15th.
No, not on 15th. 15th I'm somewhere else. Subject to your lordship's convenience. 16th, 17th, or 18th, any days. I think you stay 1 minute. 15th, 16th, 18th. If your lordships will permit me to come, 18th.
There are two learned AGs, not one learned AG. The state AG also has to argue after my learned AG.
Oh.
So you have
then
two
then the more learned AG will argue first, then with the state AG, and then I'll come later.
No, that was not the intention. I was saying the acronym stands for two persons.
There is a
He's disposed today, my lord, is not well. Keep it there.
18th.
18th
Absolutely. 19th is launched.
Friday.
Is Friday. 19th, you know. We can manage. 19th we can manage.
I won't be available on 19th. What on 16th? There's nothing on 16th.
16th I go, then I'll help up. 17th we have
What British when it will spill and go to
partner
January.
with TCI. TCI.
After your lordship fixes the two dates for them, I'll say this. First, your lordship fixes the dates for the learned.
Would that be convenient, your lordship, then with a little longer indulgence and in the first week of January? Then I think both the ages can be together and address the court in one.
I was requesting.
The difficulty, Mr. Attorney General, is that.
No, but may I say one?
There is a.
No, and that's why I also feel very embarrassed to ask this. But then what happened is I find Supreme Court has kept some parted matters also next week. So I'm on my legs in two of them. That's why I said if possible on 19th for a day, then anyway it won't be over in one day. It
May I
won't be over
request
in Yes,
Mr. Attorney General was actually possibly intending on 15th, 16th. Now he's saying 18th. Let him do it on 18th. And what I will do is, even without the learned state AG, I will finish on 22nd. One day I want to utilize.
No, I said no. Just trying to clear up my. One minute. Let me just clear up, and I must give priority to it. I understand that. Every day that 15, 16, 17, some parted matters are there. So if you Lordship give me an indulgence on 19th, I'll come and then address the court the whole day if possible, and then subject to your Lordship's further indulgence. Because I find the whole next week some parted matter, the other is there. But this matter is equally important for both sides, and I understand there are huge financial implications involved, and the mining industry must survive.
First, Lordship may slot my learned friend.
As I used to do in another high court, sometimes these matters where I find the appearing counsels have some kind of a difficulties in adjusting a common date.
Your Lordship, please.
I used to suggest that the best day is a Saturday. Nobody can say that I have a pre-engagement.
I have no problem in coming on Saturday.
So, in two matters, we disposed of sitting on a Saturday.
Then your Lordships can give me a time on 19th, and I'll continue to be there on 20th, and I can address the court on 2 full days. That's your Lordship's convenience. It's your Lordship's call. I have no difficulty about it.
Let him first finish. He has to. If it can be 18th or 19th, whatever he's saying, the Lordship may have subject to my Lord's calendar. If he can finish, then I can finish on 22nd, one day. I'll 100% finish it off.
I thought
come on 18th.
Could it be on 19th, your Lordships? 18th, again, there's some parted matter, I find. I don't know how it will get over. Because next week we thought it's going to be miscellaneous week in Supreme Court. It is not. There affects a lot of parted matters.
It's not a miscellaneous day.
No, it's not. There are fixed about 3-4 parted matters which are running on.
The week is not miscellaneous.
Week is not miscellaneous.
Friday and Monday is miscellaneous, but the whole week is not declared.
Friday I can manage. I can come. I don't mind giving up other matters. Entirely in Lordship's hands.
But I only want to make one request. Please, slot me in for 22nd. I can utilize that day. So I kindly, irrespective of.
Let him come and argue this matter.
Yes. And I will take, if your Lordship will just somewhere tell the court master, note 22nd for me, so Lordship doesn't get when it's flogged. I just want to do some advance booking because
this is like a session trial where the schedule of dates are. We'll keep it on that 22nd. There's no difficulty.
Very well. I'll be obliged, deeply obliged.
So the way the learned senior counsel completes his argument.
So the interim order may be.
An interim order there also that may be extended.
Who is?
My lords,
Yes.
My lords, I beg to appear in the fourth item in this batch, my lords. WPC.
Again, I repeat, I just find I have been telling everybody not to use that word beg. Why now we are an independent country. The question of begging does not arise. It's a colonial expressions. You have a right to represent the client the Constitution as under the statute. Why
I'm grateful, my lords. I'm grateful, my lords. I'm appearing in the fourth item, my lords, in this batch. Mr.
Yes.
Subramaniam is leading me, my
I
lord.
have seen that many a times those expressions are there.
Sometimes more out of habit or this. Lordship is absolutely right. The culture has to change.
No.
My lords, there's an interim order. The same may be extended, my lords.
Yes, we have already extended, sir. So don't worry about it.
Grateful, my lords.
Grateful,
Deeply
Lord. Okay.
Grateful. Lordship permission to leave.
Thank
you.
Oblige. Come after 1 minute. One more matter. Which one? Huh? Yes, call.
Item number 22.
Yes, it may please your lordship. I want to draw your lordship's attention to the order dated 35.
The notice has been gone. Where is the order? Operative portion of the order.
That is
order dated 30th January.
Yes, my lord. That is January 2024.
Correct. So was it communicated to them?
We have made a number of representations. Personally, we also pursued. They also assured to dispose of our appeal. The order was passed by this honorable court, the honorable division bench. Para number 3. Paragraph number 3. Mr.
No, what happened? They have not filed their.
Yes, my lord.
So the difficulty is.
Mr. P.K. Mudule, learned additional.
The situation is because the counsel was representing the LS Contemna.
Yes, my lord.
Unfortunately,
Mr. Bimadharda.
He is not. Yes, he is no more in the world.
He actually on that day that is the order dated 13/5/2025.
Yes, I say that I've seen counter affidavit.
He assured on that day the substantial part of the made the substantial.
Is what is now the situation is.
In the meantime,
extension.
Just my
while counter affidavit.
In this case, actually, in this matter, more than more than 75 number of cases, the Honorable Single Bench has passed order. And accordingly, the government has also passed an administrative order.
We'll do it. Don't worry about it. Let them come because this is a contempt. Kindly visualize. We have to see both two things. One is there is any conscious or deliberate violation of the order of the court, so we can impose punishment on them. Second is that we have to see the implementation has been done or not.
Yes, madam.
These are the two aspects. We can't reopen the issues and go into the merit.
My order of what is my rule.
Only thing is, let us see what is the outcome.
Kindly adjourn this matter next week, item number 2.
Let it be called.
For admission, item number 1.
May I please, my lords?
CMP, specialist.
My lord, in this case, the petitioners, they file a suit for a declaration of ejementary right and also file an application for injunction.
Ejementary right by prescription or necessity?
By necessity, my lord. And the learned trial court, instead of giving an order of injunction, passed an order of status.
Miscellaneous case.
Pardon, my lord?
What is this? Which order you are challenging?
The order passed by the learned appellate court.
What order?
The learned appellate court say, since there is alternative way to approach to the main road.
What order you are challenging?
Order under Annexure 5, ma'am. Dated 16/9/2025, page 60.
What is this FAO? This is a miscellaneous appeal.
Yes, ma'am, miscellaneous.
Against
an order of injunction.
Injunction.
Yes. Granted in my favor. The defendants went in appeal before the learned
Was
lower
it a
appellate court.
contested hearing or?
It was contested, my lord. Contested. And the reasoning which was assigned by the learned lower appellate court, that is at page 67, your lordship, running page 67, last part, last 4 line. Convenience is not the test, but the test is of absolute necessity. In the instant case, since the plaintiff petitioners are claiming right of way over the suit land A of the defendants, they have to prove that there was no other access on any side to their property, but accept a bold statement that they have failed to prove the same. Rather, the defendant opposite parties are submitting that there is a passage under plot number 125, that is government land, towards the east, and another passage over plot number 126 belonging to Srinath Pareda towards north from the house of the plaintiffs to go to the main road. Well, my responsible submission would be, there is in fact, this is a government plot which has been referred to, there is no road actually. They say it is a Patita land.
Then how he came to, because this is a passage which you are using for a long time.
Yes, my lord. Because
are you an initial owner or a subsequent purchaser?
Well, the plaintiffs as well as the defendant, they purchased from the joint owners.
From the common owner.
Common owners.
Yes. So
and in the respective
your deed reflects any kind of a road.
Yes, my lord. In the sale deed which was executed in favor of my mother-in-law, there is a statement, there is a recital that 7 feet 7 kodi, that is around 2 some feet, 3.25 feet, that is left for passage. And in their salary also, it is also been reflected.
So there must be a boundary of the entire property. Boundary reflects on any side the passage.
My lord, their salary recital says that
No, recital is one. I am asking about the boundary. It is butted and bounded on the north, south, east, west. Is there any description of the passage on any side?
the passage is exists from the towards their south
I'm
side.
asking the sale deed, sir.
Sale deed, my lord, there is no sketch map specifically reflecting that.
But there
Step
must
and
be,
accept
there
the
must be a
recitals.
description of the property.
Description of the property is there.
With the boundaries.
Boundaries has been given. Yes.
Any reference of the passage on any side?
It is stated, my lord.
In a on a north, south, east, west, any passage. When it leads to your property, there must be a passage thrown in the boundary.
Sale deed, the sketch map is not there with me.
Or a sketch map may not be there, sir,
Yes.
but there should be a description of the property.
Yes, my lord. Description there, it is mentioned.
That is what I really wanted.
My lord.
Is it in English or any other language?
Vernacular, Odia vernacular.
Oh.
ରାସ୍ତାକୁ 7 କଡ଼ି ରଖାଯାଇ ବାଦ ଦେଇ ଦକ୍ଷିଣ ତରଫରୁ. In our cell it is maintained. From the south side, 7 kodi left. And in their cell also it has been mentioned.
That should be on a north side of their plot.
Yes, ma'am.
On the northern side of their plot.
Yes. So therefore the learned trial court saying that because all these things are to be laid at the time of trial of the suit, better course should be that status quo should be maintained because I have been using that for more than 20 years. I purchased it in 1984. It is December 85. They purchased in October, in August 85. 4 months gap only.
But the track report says that you are a plaintiff.
I am the plaintiff.
So who was contesting the defendant numbers 1 to 3?
All contested. All contested.
All means how many defendants?
3.
3. So they must be represented by their lawyer in the trial.
Yes.
So it's better just to give another chance.
Fine.
We are. I'm directing you to serve the notice or a copy of this application upon the learned advocate representing him.
There.
So that at least he will have a notice that the matter is there. Otherwise, we'll proceed in ex parte on that.
My lord.
So despite the service have been affected upon the opposite party numbers 1 to 3, there is no This order is passed long back. You wait for another. Yes.
Item number 2.
Who is appearing in 2? You
We
want
are
a
appealing
network?
for opposite parties, my lord. They are asking.
Senior suffering from fever.
Yes, 9. Yes, next. Again. Yes, got it.
I'll be this on list.
Item number 3.
Item number 1, sir.
Lordship's defects have been removed.
Where is 500 rupees?
Lordship defects have been. It was actually the order sheet was uploaded yesterday only. I have removed the defect.
The defect pointed out by the staff reporter.
So it's appointment of a substitute arbitrator.
What? What has happened? Which? Where is the arbitration clause?
Lordship, in this case,
Oh, sorry. Then let the
Lordship, my mandate gets over on the 19th.
Oh, then list the matter on next week.
19th.
19th.
My lord, I think I need to file a fresh wakalatnama because it's a new. My lord, I was appearing for the opposite party, my lord. But I think in this case, I need to file a fresh wakalatnama. So for that purpose, I need some more time, at least 2
What
weeks.
more time? Wakalatnama, if we
And also in the meantime, we'll file a counter, my lord, a formal counter.
Let us see first whether there is any scope for a counter.
But last occasion, we have tried to apprise your lordship regarding that. So.
But there was a defect which cannot be done. So let it come on that next week. In the meantime, you secure the Vagalatama, you have instruction.
Yes, my lord.
So,
I have obviously, yes, my lord. Yes, I have the instruction to appeal, but I think
meaningful
I need to file.
instruction has come.
No, there is no formal instruction, but obviously because I was appearing in the previous case.
Meaningful instruction.
Formal, my lord.
Formal or
because I need to have a vakalatnama or at least some kind of.
That I understand.
My lord.
Come in the next week.
Item number 2.
The arbitration clause is page 25.
25.
Yes, ma'am. Settlement of disputes and arbitration. Clause 25.
Yes, yes. So there is a preconditions. Have you complied?
Yes, sir.
Where is the compliance? First thing is
demand that
is it relating to a specification, design or drawing and or instruction or as to quality of workmanship?
There is the disputes regarding to non-payment of dues.
So
that is, I have made a demand on Annex 3 Thereafter, the appeal was made on annexure 4.
Any question, claim, right, matter arising out or relating to a contract. That's
Yes.
true.
Yes.
Then you will have to approve within 15 days to the engineer.
Yes, my lord, that is demanded and under annexure 3, my lord. Page 28, starts from 28.
Executive engineer is the engineer in charge.
Yes, my lord.
Then
appeal under annexure 4, my lord, to superintendent engineer.
Page
starts from 35.
Then
thereafter, the request for DRC, dispute resolution.
yes, that is what I wanted.
That is annexure 5. Starts from page 41.
Yes, then
Thereafter, request for appointment of arbitrator on section 21 of the arbitration. That is on annexure 6. Starts from page 49.
you serve the notice.
When the union government is party, I may be allowed to serve copy, extra copy. Only union government is party. They have also entered appearance case.
My lord, along with 54, the 52 also taken up. There is what I received the instruction that it is similar in nature. So both the case may be taken up after vacation.
No, we are directing him to serve the notice. Are you waiving somebody, Mr. Swapto Sindhu
Kashyap, yes. He is our associate, my lord. He is a senior panel counsel of my panel.
We have served him a copy. He has his.
I'll serve a copy.
Yes.
Just to expedite the matter, otherwise you'll have to file a petition here.
No, my lord. Let them serve the copy of the expert. Will expedite.
Learned dear.
Item number 3.
My lord, I'm appearing in BC. The conducting counsel, Mr. Yogesh Vinayar, is seeking illness. For that reason, I'm seeking for the time, sir.
There's 4.
Item 4.
Public.
Demand notice was
First, tell me show me the arbitration clause.
my lord. It is at running page number 21.
21.
Part 11.
Yes. Whether you approach for a joint discussion.
My lord, we have issued demand notice and
No.
there was no
Have
response.
you asked for a joint discussion have you stated somewhere that there was a joint discussion or they refused to undergo with the joint discussion?
There was no response from their side.
Please show us that these are the preconditions to the arbitrations. Have you exhausted those conditions?
Yes, my lord.
Show
My lord,
us. It says that anything, then it should be resolved through a joint discussion of the authorized representative. Where is your averment that you wanted to have a joint discussion, but they did not?
my lord, in para 6, it is at page number 8.
8.
Yes, my lord.
Yes.
That it is submitted that till that no response is received
from the respondent.
No, that was in relation to section 21.
21.
Prior one.
My lord, in page number 6, 4, that having neither received any justifiable, not the
Yes,
outstanding
yes.
amount.
That is what I really wanted. Para?
Para 4.
No, sir. There should be a very clear awareness.
My lord, the legal cum demand notice was issued on 24/4/2025.
I have seen that was only a demand, but the clause is different. That if there be resolved through joint discussion of the authorized representative of the parties. So you'll have to say that you invited their attention and wanted to have a joint discussion, but they refused or declined not to have. Then you are invoking the clause. Yeah, sir. Returnable on 9.
My lord,
sir, returnable on 9.
Item number 5.
This matter is connected with another ARBP 67 of 2025.
Why you wanted two arbitrators? Why? Why it is connected? There will be one application under section 11.
Two agreements, two contracts, two work order, parties are same, issues are same. So only for that reason, it will be convenient for the Honorable Court to take both the matters.
Where is the other matter?
ARBP 67 of 2025, not at least.
Why it is not listed? After 66, why 67 is not listed?
That
Huh?
matter was earlier listed.
What has happened?
So that day for us it is not listed.
This is the matter next week, both the matters. Record and order. It appears that another application for appointment of the arbitrator being that number you give, 67. Okay. The same of 4.
Yes, madam.
Same clause.
Yes, madam.
But the opposite parties they are also same. Two agreements.
Yes, madam.
Where is that clause? Yes. Same
My
one.
lord, page 20.
Item number 4. Next.
Item number 7.
My lords, may kindly have the arbitration agreement at page 97.
There. Page?
The page 90 is the clause 25, which is a multi-tier dispute resolution clause, my lords.
90.
And page 90.
Clause number?
25.
Oh, this is another matter like this.
Yes, it's a multi-tier dispute resolution clause. And then, my lords, will find...
Have you exhausted all the remedies?
Yes, we have, my lords. We have.
Where show us that first you have approached the engineer in charge.
Yes, my lords. My lords will kindly have page 113. This is my notification of claims. These claims were denied.
No. You
First, I have to notify my claims, my lords.
If there is any dispute with regard, even the dispute, the nature of the dispute is what?
The nature of the dispute is non-payment of money, etc., my lord. So first I have written to the executive engineer.
First you have to move the engineer in charge.
First the executive engineer, my lords.
That is the clause says engineer in charge, maybe
yes, right, my lord. So that is at page 113. That is at page 113. 113. That's on 8/6/2022 to the executive engineer.
Yes.
Then my lords will see it is declined.
Then if he has not taken a decision within a
yes, my lords. Yes, my lords. I write to the superintendent engineer. To the superintendent engineer, that's at 121.
Yes. Yes.
So to the superintendent engineer on July 13th, my lords.
Yes.
Thereafter, I have written to the chief engineer again, my lords, on 20th.
One?
On 28/2022 at page 126, my lords. I have written back to the chief engineer.
Just yes.
At page 126.
Thereafter
appeal to the DRC. My lord will find that at page 133.
Yes.
Thereafter, the DRC rejects it, my lord, on 29th of November. That's at page 152.
Yes.
Then I invoke the arbitration clause. That's on 3/1/24 at page 153.
Is a time barred claim.
No, my lords, I'm following up the process, my lords.
Oh no, sir, 2018, the last bill of the payment was made.
No, my lords, the 2018, my lord, I went into CIRP.
Service keeping the point of limitation open.
Grateful, my lords, grateful.
Yes.
Item number 8.
Lord, in fact, in this case, my lord, I am appearing along with Mr. Barik. Mr. Barik, my lord, in fact, we had lodged caveat before, and the petition for section 11 has not been served on us, my lord.
My lord, we had filed a caveat. We are appearing for the
We have filed a caveat, my lord, Mr.
Why you did not serve? Dekhi.
My lord, we were
Caveat check.
not aware that a caveat has been filed. My lord, we had no communication. And
No, you do not know. There is already there. These are all uploaded there. So why? This is not expected.
my lord, we really did not have.
Then what is the utility of filing a caveat?
My lord, may
If you do not
kindly give
serve,
another.
then what is the utility?
My lord, may kindly give another. It will inquire and take instruction.
Sorry, serve the copy. 1 week by this 9th. Who has lost the caveat? You?
My lord.
Yes.
The name?
Nikhilesh Barik.
Appears and submits that he has lost.
Item number 9.
9th.
The application under section 11(6) for appointment of arbitrator. Prior to this, I have also approached this honorable court earlier. Lordship may see page 25. Page 25 is our last order. The petition of the suit application has grievance with regard to payment made for printing of question papers. In course of hearings, Mr. General and Count, the petitioner fairly submits that clause 23 of the
that you went to the writ petition, and the writ petition, the writ court has relegated you to the arbitration.
Yes, the petition said that there is a clause available in the
Correct, I understand. Based upon a furious judgment.
No, I'm saying that prior to this, my lord, I have approached, and this is the observation of the court, and thereafter I have filed this application.
So you did not approach under section 11. You approached under the writ.
Yes. in agreement, my lord, there is no such clause for appointment of arbitrator. But in the bid document, the time of purchasing the tender, there is a condition for resolution of the dispute. Lordship may see.
Where is the agreement?
Agreement, my lord, agreement, annexure 5, my lord. Annexure 5 is the bid document. My lord.
No, I am talking about the agreement.
Agreement. Yes, done. Agreement at page 55, annexure 8, page 55.
There is a terms and conditions of the bid.
Terms and conditions, annexure 5. Annexure 5 minutes starts from page 33. And the relevant clause is at page 41, 23 clause. Page 41, 23. Resolution of disputes. Annexure 22 is my letter asking them to appoint an arbitrator.
Service, keeping the point of maintainability of the Section 11 application open.
My lords, I appear. Well, it's here the first approach would be conciliation and then arbitration. And the notice inviting up is also regarding.
Madam, you were there in the writ. The court has directed immediately to file a Section 11 application. Can you take a plea? It's a division bench order.
Yes, my lords. That
So- And you have conceded. Very interesting way of dealing with the matter. He went for a raid,
Yes, my lords.
perceiving that there is no arbitration clause. At the time of hearing, he says that there is an arbitration clause.
Well, there is an arbitration clause.
And you conceded, yes, there is an arbitration clause. And therefore, last paragraph.
Well, it's here the dispute resolution clause talks about two things.
Whatever.
Yes.
I have seen the document,
Yes,
the contract which was entered into. It does not contain any
arbitration
clause.
Bid document.
And there is a special terms and conditions.
Yes, my lords.
In the bid document, it says that at the time of entering into the contract, the TIA can change or modify or delete any of the terms and conditions of the bid document. So it will be perceived that they have changed it, they have deleted it, and you agreed. Then we have to go by Section 7. Not only on the basis of an agreement, even by your conduct, by your consent, everything can be done. That is an arbitration. I treat that order as an arbitration agreement. Service, you come and then you appear.
Yes, sir.
Item number.
Number 10, Your Lordship, on the last occasion, Your Lordship had directed learned DSG to take instructions, Your Lordship.
DSG.
We seek instruction, but I didn't receive. Let's give more time.
What are you doing? If you do not receive, we proceed and decide the matter in your.
Let's give a last chance. Otherwise,
Another opportunity to take instructions.
after
11.
Item 11, the agreement clause is on page 14, my lord.
Page
14, 1-4. Clause number 11.
What is this agreement?
And respondent will supply the machineries.
Yes. Now, non-payment.
Yes, ma'am.
Yes.
We some outstanding amount have been.
That is the non-payment
My lord,
of your dues.
My lord.
Where is Section 21 notice?
My lord.
Request at page 30.
My lord.
Where is the proof of receipt?
Page 40.
Service 9.
My lord.
Item 12.
Item 12, my lords, on the last occasion, my lords will recall my lord, Miss Rath, learned senior counsel appearing for NALCO to take instructions. This is the case where the learned arbitrator passed away, my lords.
Your Lordships, we are filing a
Arbitrator passed?
No, arbitrator passed away, my lords.
Your Lordships,
I could not hear. What?
passed. He
has
died.
passed away. Oh, that's
Yeah.
true.
Your Lordships, we are filing a detailed counter today, Your Lordships. It's required, Your Lordships. There is
Madam,
also some complication
when
from
the
IBC.
earlier arbitrator was appointed, definitely after giving an opportunity to object, when he passed away, died, and then substituted arbitrator, you are seeking to file an opposition.
Your Lordships, they
I
have,
am really surprised.
they have come up
with
after 6 years, Your Lordships.
whatever be,
Your
is there
Lordships,
any period of limitation?
Your Lordships, in absence 137 of the Limitation Act. will
That
say-
is the
And Your
resistory
Lordships,
clause, I can understand. Is a
there's also an
resistory
issue,
clause.
Your Lordships. They have.
My lords, we are covered.
Close.
My lords, may I say, we are covered under Section 60, subsection 6 of the IBC, which says
Your
from the
Lordships,
date of
they have-
the moratorium till the date of the approval the entire period, my lord, is not to be counted in
Exhausted.
terms of Limitation Act.
Your Lordships, as far as Section 14 is concerned, they had no legal embargo to come. We had
No.
counterclaim for our counterclaim.
Why
But Your
not?
Lordships, there was another issue. He's not filed the, the resolution which was there, what had they have presented, whether this debt was at all.
Sir, RP was approved by the NCLT.
We do not know. They've not.
Do not know.
They've not.
Do not know.
We do not know how this particular litigation was shown. Your Lordship, we file a detailed counter. Let them go through that. Let it come next week, Your Lordships. We'll take our chance on both sides.
That may be for some other beneficial purposes, but
Your Lordships, it's a PSU.
not for.
I'll have to file a counter, Your Lordships. Your Lordships understands how PSUs work, Your Lordships.
Mr. Roth, the London senior advocate, appears and submits that an opportunity. In both the matters,
Both the matters, we are adopting the same counter which we are filing in the first matter.
in other matters,
Item 13.
Well, the arbitration clause as clause 25 at page 11.
no filing of the counter. Only thing is to be listed on that next week.
Clause 25.
For record, Ms. Roth submits that she has filed a counter affidavit in relation in ERVP number 93 of 2025. Stop. She submits that since the point taken in the counter affidavit is identical and similar in the instant writ petition, therefore such objection must be treated to have been made in the instant application as well. In view of the above, this is the matter on such cases. Which one?
13. Clause 25 at page 11.
Page
11. Clause 25.
25.
Yes, ma'am.
Where is what is the dispute? What is the nature of the contract?
Contract is rural water supply.
What is the nature of the dispute?
The dispute when the payment has not been made.
There is section 21.
Section 21, page annexure 4 minutes. Starts from page 17.
Any response?
No, madam, fast.
They must have replied to a letter or something. I'm just asking.
No.
Yes.
Well, I'll take instruction whether.
What instruction? Nothing. Copy has been served.
Yes, my lords.
What more?
My first time,
you
my lords.
make the payments, take instruction.
Well, it's first time it has come up, my lord.
So what? Is it a rule under what provision of law that in the first day it is automatic adjournment?
No, my lords, whether.
On the second day, restricted adjournment.
My lords, I take instructions whether this can refer to be.
When the copy was served on you?
30th October.
What you were doing for such a long time, more than a month?
My lords, we have sent
1.5 months.
My lords, we have sent letters to the department.
No, if they are apathetic, they are so complacent, then don't care for them. Proceed. Why the matter would get delayed?
It's 1 week, my lords. 1 week, my lords. I'll I'll just take instruction whether this can be referred to an arbitration, my lords, because
I
there is
think
a clause.
I have an opportunities on this weekend. I will definitely try to project it. Next week on her prayer.
Item 14.
Lord Sir, the arbitration clause is at page 37. As part of annexure 1.
What is the nature of the contract?
Nature is regarding running the flying training school at the Bhubaneswar airport and other airports, small airport strips in the state of Orissa, which was entered earlier. Gati used to do it. And now the petitioner has been inducted into it from 2007 onwards. And in fact, the work started in 2009 and it's for 20 years.
Yes.
And certain disputes.
Have you referred it to the Chief Secretary, GO?
Yes, my lord, that has been done. Which is,
of the yes,
which has been reflected in our 21 notice, because those were voluminous documents. I didn't make it part of it, but that has been described in our 21 notice.
Where is that?
Subject to your lordship's lord indulgence, page 73. .26 onwards, if your lordships would see page 73 and 2.27.
Service line.
All three are state of Orissa. So if your lordship permits me, I'll serve extra copies on them.
Yes, record her submissions. She appears and submits that she has instruction to appear.
Item note 15.
Your Lordship, I am appearing from VC. Item 15, I'd like to withdraw. Memo for withdrawal is already there at flag B.
Next.
Item note 16.
This is a matter. Substituted arbitrator needs to be appointed. Lords, in this case,
for the other side
is on VC, my lords. Lordship, on their own admission, they have admitted that the arbitrator, there is an arbitration clause, and during pendency of the arbitration proceeding, the umpire, the presiding arbitrator, as well as our arbitrator, both are High Court judge and ex-Supreme Court judges, they passed away. Now, there was a writ application pending in the High Court. And while disposing, your Lordship may kindly, wrongly or rightly, the writ application, I am aware of SB pumps. Your Lordship may kindly see the order in the writ application, which is at page 27.
Yes.
The matter is taken up through High Court. Mr. P. Mukherjee, learned counsel for the petitioner, is present. 3 arbitrators, 2 arbitrators already died during pendency of the writ application. Mr. Mukherjee further submits that his client has approached the opposite party for appointment of a new arbitrator. A memo has been filed to withdraw the writ application with liberty to raise the points in dispute before the newly appointed arbitral tribunal. Page 27, annexure 4 to the application, my lords.
Yes.
Now, the para 4 is important. The other side, Mr. L. Mahapatra, learned counsel for the opposite party, appears through virtual mode and submits he has no objection to the prayer made by the learned counsel for the petition.
No, but this no objection to the prayer means
appointment of arbitrator.
No.
For the tribunal.
For memo, for withdrawal.
No, my lords. A memo has been filed to withdraw the writ application with liberty to raise the all
That
all the
that he
points
has no
before.
objection. That he has no objection.
For
So you
newly
withdraw.
appointed arbitral, that is part of that memo. For newly appointed arbitral tribunal yet to be formed. Now, Lordship is your Lordship knows about the judgments. Their substituted arbitrator needs to be appointed, and I need not, because there are three.
No, I understand, but you are taking shelter under the admission.
That is one. That is not one.
Problem on admission.
That is one.
No.
That is one. And second is your Lordship, there my notes of submission along with the judgments on which I am relying upon. One is Huawei Technologies, then Yashish Construction. All these judgments, my lords, have been that where there is a death of an arbitrator, the court can, your Lordship, I need not.
Definitely, no doubt about
I
it.
need
Where
not.
is the difficulty?
I need not.
And there should not be a new adjudication which is to be made. Now, what he says? Sir, your audio, you have an audio problem, sir. Yes. No, we can't hear you. Yes.
He has also filed a written notes of submission.
What he's saying, we can't hear you.
I understand.
That's sometimes this is the problem with the virtual hearing. His device is not actually proper.
Yes.
Your device has an audio problem.
He cannot listen, I suppose, also.
No,
No, he can listen. Yes, he can listen. Yes, he can. He's acknowledging it.
No, you're not audible. We can only do a lip reading, nothing more than that.
For that need you specialized.
Can you log out and then rejoin? Permit him.
In fact, the notes of submission which he has filed, he has agreed to that. But now he is prohibited from choosing their arbitrator. We have already chosen our arbitrator, R. Bhanumati, retired judge, Supreme Court, and we have intimated that we have already chosen our arbitrator, you choose. They kept quiet. Again, a reminder, kept quiet. And since 30 days is already over, they have forfeited the right to choose their arbitrator. It's your Lordship. And those two arbitrators will choose the third arbitrator.
Go on. Where he practices normally?
He is son of Manas Mahapatra, senior advocate, but he is stationed in Delhi most of the time.
Yeah. Yes. Yes. Actually, he has a problem in device. Either software is not supported or there is some
needs update.
May not be, but some interference in the software.
I don't think there is any problem here. It is with him.
Yes. What to do?
It's on your Lordship now.
We can't.
But the notes of submission and judgments which they have filed and we have filed, your Lordship can decide on that. If
Sir, we can't hear you anything. You have filed your notes of submission. I will take care of both and pass the order. That's all. At least nod your head in affirmative or negative. Yes. I do not know. It was a half affirmative, half negative.
It was.
So what is that? Yes. Say clearly. Affirmative, negative, what?
Gesture.
Nod your head. Sorry. Huh? Anybody counterpart? His counterpart is here.
No. No, he's not.
Their side, the notes of submission is not filed.
They have served a copy on. They have served a copy on.
Sir, we can't because your voice is not coming, so we don't know. Now I'm putting a question, you just nod. Have you filed the notes of submission? Yes. In the computer, is a PDF form? E-filing. Yes. We'll trace out. So, should I dispose of the matter on the basis of the notes of submission? Yes. Finish. Yes.
Can I share my copy?
Yes.
It becomes easier.
Let me have the privilege of his copy. This is your copy. Anyhow, just keep it the matter on the next day for orders, and I will dictate. In the meantime,
I don't know 17th.
Can it be on 9th?
19th.
This is a passing of the order, nothing more than that.
Because there is another problem, my lords. There is a wire here which is very in a very precarious state. Needs to be stapled or
No, it should be
chances of
covered. It should be covered with some kind of a.
Yeah, or else there will be.
Oh, this is the camera wire.
Yeah.
He just put some kind of a coverage.
I don't know 17th.
If I may please your lordship, this is with regards to the appointment of arbitrator pursuant to the valid arbitration clause, which is at page 42, my lord.
Page
42, clause Q.
Clause
Q, my lord. Any disputes arising out of between the allottees and the cooperative shall be referred to the arbitrator of the cooperative. But
what is the dispute?
The dispute is with regards to a common.
This is relating to a cooperative dispute?
No, my lord, it's not a cooperative dispute.
Then what is the dispute?
The cooperative society developed a property. It sold flats to the
Is member?
No, my lord, it's not the member.
What are you talking about?
It sold the flats to its members as well as other employees who belong to the SBI Bank, my lord. Not necessarily.
So that must be a cooperative of these employees.
Yes, my lord. They're
Is a housing cooperative.
Yes, my lord.
So,
but not in the sense that all.
If you have any dispute with the cooperative because you are an allottee of the flat or a unit, then this is a dispute under the Cooperative Societies Act.
My lord, there is no dispute with regards to the functioning of the cooperative.
No. Even anything which concerns the cooperative action. Where is the Cooperative Societies Act of the Odisha?
That, my lord, is referring to the amended section which states that any dispute out of the members and the cooperative society.
I know that once you are admitted and sold, that you become a member of the cooperative.
No, my lord. For that, there is to be a member of the cooperative society, you have to apply, my lord. Then you have to be a member. There is a prescription charges. All those formalities are different, man. But in this case,
what is the nature of the agreement? Show us.
The nature of the agreement, my lord. There is a cell deed.
No, I'm just thinking about Booz Allen's case of Justice Ravindran. For that reason, I'm asking you a question.
Yes, my lord. But my lord, with respect to the same being a dispute, it is not a dispute either with the functioning of the
No, it is
cooperative.
not. The section, that's why I have interpreted the section of another States Cooperative Societies Act. There, I have said that it is not restricted only to a functioning of the cooperative. It has covered more, provided it is a member.
Yes, my lord.
Maybe. So only thing is, we just wanted to know. Show us.
Yes, my lord. The annexure 1.
The sale deed has already been executed.
Yes, my lord.
Thereafter, what has happened? What?
In the sale deed, my lord, when the flats are sold, all the common area, including the flat unit, was sold to the applicants, my lord. But
Common area cannot be sold. The permission to use the area in common is given.
But not the clubhouse. The clubhouse is the hall, my lord, wherein all the functions, the gym is presented, my lord.
Yeah.
My lord, may I go to page 40, clause 13? It exclusively states that the intended facilities of the club as outlined in the brochures are tentative and may vary at the sole discretion of the cooperative. The membership scheme is open only to the allottees of the apartments and shall be in the name of the resident individuals only. Facilities of the club can be availed by the members and their spouses and children. Members may also bring in guests on payment of guest fee as per the club rules to be prepared by the cooperative.
Just 1 minute.
Yes, my lord.
Yes. Then what happened?
So, my lord, from the bare reading of this provision, it is clear that the control over that hall or the club remained with the cooperative society, my lord. But after the flats were allotted, the allottees, they formed a registered welfare association society and they forcefully took over the control of that club, my lord. So, hence, because of that,
No, I was just reading others. Yes. What is this?
My lord, may first come to clause 13, that is at page 40. The headline is the club.
Sorry, what you were? I was reading the other, the entire sale deed. Anyhow, there's
My lord,
which page you were referring?
Page 40, my lord.
40.
Yes, my lord.
These are the terms and conditions, or these are the
This is
things
the
from the brochure.
This is the allotment form which has been made part of the sale deed, my lord. So at page 40, the clause number 13, my 1-3.
But these are the part of the brochure.
It has been made part of the sale deed as well.
I do not find from the sale deed anything.
My lord,
I do not find from the common areas has been defined in a very cumbersome manner.
Yes, my lord.
It does not talk about normally common areas as defined in schedule such and such.
But because, my lord, it was an amalgamation of a huge number of
small
plots, that's why such general description have been given in the sale deed itself.
No, it's not a common area. Club is a different area.
Yes, my lord, come to page 31, it would be clear.
What?
Page 31. It shows the entire project area.
So it becomes a club, becomes a common area.
No, my lord, it is not a common area. That is my whole submission.
No, I am saying that it is not a common area.
It is not a common area, my lord.
Then?
So the operation or the management of that club was not transferred to the apartment owners, my lord. It remained with the cooperative society, which is further clear at page.
Then why you wanted an arbitration agreement?
Because, my lord, I want the arbitration because the apartment owners, after forming a welfare society, they have forcefully taken over the functioning of that club.
Sir, understand that where is an arbitration clause?
That is at page. Arbitration clause is at page 42, my lord.
Show us what is the agreement with you. What is this agreement with you? These are the brochure.
This is the brochure, my lord, which is made part of the allotment for. So
sir,
first,
this is arising out of allottees.
Yes,
now these are the association is a conglomeration of the allottees.
No, my lord.
All the allottees are the member.
No, my lord. There lies the difference. What I may be permitted to clarify: the petitioner society is not the apartment society, my lord. It's a different entity. It developed a property.
Sir, I understand. What you think? I have not. When I read the sale deed, I could understand that what has happened.
Yes, my lord.
They formed a society. They purchased the land. It was an agricultural land. They initiated a proceeding for conversion of the land from agricultural to homestead. That was granted. Thereafter, they wanted to construct a multi-storied building with an intent to sell to the outsiders. And then you, being an outsider, approach them, and they have started selling.
I am not the outsider. I am the seller. The cooperative state bank.
I mean, not you. That's the purchaser came. The purchaser of the sale deed, where you have said he came and purchased the one flat at something on the second floor or something. He purchased it.
Yes, madam.
Now you say that once you developed and transfer, you say that it is not only the flat of 1700 something square feet, but a proportionate share in the land also is transferred to you. And the third is the common areas which are already defined. You will be entitled to use that in common to others.
They are entitled to use that also.
Common to others. That is what you agreed.
Only catch is
now once these terms and conditions have been given, now I find there is one application form at page 34.
Yes,
for what?
That application form, my lord, this sale deed has been executed after the said application was accepted by the State Bank Cooperative Society.
Correct. So they applied with this application and done it.
Yes, my lord.
Now I find that so far as the club is concerned and the common areas are concerned, they are under different clauses. One is clause 13, another is clause 14. Clause 14 talks about common areas and facilities.
Yes, my lord.
The moment a different broadhead is provided, that means that the club is not within the particular common areas.
Yes, my lord.
Now, if it is outside the common areas, then if somebody has encroached or trespassed into your property, arbitration clause.
No, my lord, I am not seeking for a I'm not seeking for a decree of either recovery of possession.
What? Then what?
I am seeking for damages only.
What damages?
That I have stated in my
It
section
can't be done.
21 application.
File your affidavit. Maintainability is kept open. You are for?
Opposite party, my lord.
Yes, file your opposition. Raise a point of dema. I do not think so that it is maintainable.
Because, my lord,
No.
I'm not.
The opposite party is permitted to file. What is the value?
Plus 2.234 crores as of now. 2.34 crores.
2 crores.
Yeah, 2.3.
or whatever. 0.3, what is? This is an application under section 11 within bracket 6. For India, which is
And as it goes to the order gets communicated.
There is no arbitration center, so I'm not aware of arbitration center there. It is a venue is fixed by the arbitrator. He is liberty to do it, fix the remunerations, everything. So that is always left to him or schedule 4. Now, remuneration in terms of schedule 4. Agreed? Did he agree?
Let me leave that open.
In fact, in all arbitrations now schedule 4 in arbitration center, in all arbitration the coordinator assesses the fees in terms of schedule.
Coordinator assesses the fees of the arbitrator.
The coordinator arbitration center, as per the rules. There's
As per the
arbitration
High Court
rules.
arbitration
High Court
center
arbitration rules. Sir.
So the rules have also come. Yes.
Item number 20.
And that's on last occasion, notices were issued and the same has been served.
It is. There is no appearance.
Yes, my lords. Nobody is
So give
appeared.
one chance next week. There is no appearance on behalf of the opposite party, despite the service having affected upon it. Stop. To give another chance. This is the matter next week.
19th.
Good.